Right, well, afternoon everyone. Thanks for joining us for the latest episode of At the Coalface. This is our series of webinars, Tenet Run, in relation to fraud and financial crime. Thanks for giving up an hour of your day. It's a lot to give up. I know there's a lot of content out there, so I really appreciate you either having registered to watch this back later or joining us live for the webinar now. Now, so for those of you who don't know me, my name is Arun Chauhan. I'm the founder and director of this law firm, Tenet. We're a law firm that specialises in disputes, investigations and advisory work on compliance and regulatory issues arising out of fraud and financial crime. Those of you who have been with us before will know that I usually do this without any glasses, but in the last month or so, my eyes have really gone bad, and so I'll be wearing glasses for the majority of this. So any feedback on the glasses is always welcome. The aim of these episodes is really to speak to people who are on the front line dealing with issues around fraud or issues that could relate to fraud. And, you know, we've had previous episodes, and my colleague Paula will put some of those links up in the chat later, where we've dealt with issues like procurement, ESG, cyber, investigative journalism, issues of that nature, which have been really, interesting to talk about with previous guests. Today, I'm pleased to be joined by Tristan Bramble, US qualified attorney, and who specialises in financial crime advisory work. I'm breaking from the norm a little here. We tend to have external guests, but I met Tristan in Westminster about, I'm going to say 8-9 months ago at an event on whistleblowing. And as they say, the rest is history. He's recently joined the firm, but he has some really interesting history in terms of his backstory in the US and working over here. So Tristan, welcome to At the Coalface, and obviously hello again. But yeah, do you want to give a little intro about yourself and then we can kick on?
Absolutely. Thank you, Aaron, for that kind introduction, and delighted to be invited onto your series here. I have 15 years of transatlantic experience in the US federal government, 8 years in Washington, D.C., and then 7 years here in London. And so this transatlantic experience has really broadened my practitioner experience, and hope to give your attendees something to take away. Also, I am a steering committee officer of American Qualified Lawyers in London, which is a group of about 700 or 800 lawyers in the city, sort of a support group there. And this community of practice is another one that gives good perspective on the broader reach. And as you mentioned, I recently have joined Tenet as a consultant, helping to lead our London expansion. So it's an exciting time to bring that London and international experience to bear, and hopefully we'll have some interesting discussion today.
Yeah, brilliant. Thank you. And thanks for being mad enough to join us. And yeah, hopefully this is something that will be good fun along the way. Now, anyone else who's joined this session before will know what I'll do. Be waving my hands around as we have motion censored lighting in here, which is all very environmentally friendly. So often the lights go off at about 20 minutes and I have to rock back and wave my hands. Other kind of practical stuff. At the end of the session, there's a feedback form. If you could just have a quick look at that and feedback and give us any comments, that'd be really helpful. Q&A, if you could put any questions you've got in the chat, Tristan and I will deal with those in probably the final 5 minutes to all of the end. And of course, anyone who's registered for this event, at the end of this, you get a copy of the recording, and that'll be sent out, and a kind of like an ebook, a PDF of the main takeaways that we've talked about. Now, the plan, as always, is to cover 5 topics broadly. We're going to chat through those 5 topics over 45 minutes or so, and then get to the quick Q&A. So the first thing we're going to talk about is kind of the US attorney perspective from Tristan, from looking at enforcement in the US and considerations around economic and white collar crime. We're then going to talk about controls beyond cost. Tristan will talk about how he came over to the UK to work at a major retail bank, and we're going to try and see what we can learn from the kind of big compliance program he's involved in there, and what could be taken to smaller organizations and also organizations outside of the financial services sector. Obviously, if you go to any webinar or any event around fraud at the moment or financial crime, the failure to prevent fraud offence always comes up, and it's not going to be a reason not to come up here today. So one of those key issues about FTP, failure to prevent fraud, is going to be around whistleblowing. So we're going to talk about whistleblowing for a while. We're going to talk about attitudes to risk advisory from a US perspective as well as a UK perspective, and Tristan's experience of that. And then we're going to finish around a bit more on failure to prevent fraud. Why should firms and organizations overseas be paying real careful attention to this? So going to delve right in now. Tristan, when I've done a few podcasts and people have asked about why I have got into the law, I tend to talk about things like Indiana Jones, but then also about lots of legal television series from the US. Now, showing my age, I'm thinking of stuff like LA Law, and then very, very much towards the end, when I was probably starting to work, Ally McBeal was floating around. But the US always throws out these kind of really gripping dramas. You know, people have talked about Suits, and I remember The Good Wife, and all these Grisham novels. And it tends to kind of lend this perspective that the US is pretty strong with its legal approach. And historically, I think the US has led the way on enforcement in response to white collar crime, corporate crime failings. And, you know, we know the law and failure to prevent and other laws here are coming in. But, you know, with your time at the DOJ, Department of Justice, the US environment, you know, we can see laws aren't enough. The enforcement threat needs to be quite strong. And what's your take on that? What's your view on how important the enforcement threat needs to be from your time in working in the US?
Yeah, that's a great question to start off with. And rules. What are rules without enforcement?
Yeah.
If they're just there to look at and imagine. And for a long time, the U.S. has claimed the stake at being a leading enforcement, having the leading enforcement agencies in the world. And it was my dream after going to law school in Philadelphia, Temple Law, to work in Washington, D.C. for the federal government. So I spent 8 years climbing the ranks there at two major federal agencies, one that covered everything from international trade, risk management, food, agriculture, et cetera, to the well-known Department of Justice. And each of those agencies were 100,000 employees large, right? I mean,
Wow.
the Department of Justice had 30 component offices. Now I sat in the Justice Management Division, which is the oversight arm of the entire apparatus. Now, 30 component offices included the FBI, the DEA, Drug Enforcement Agency, the Criminal Division, the Civil Division, Civil Rights Division, et cetera, Interpol. So I got to know and understand, how it functioned and how it worked. And my role as an attorney advisor was really to protect the integrity of the department and the enforcement structure. So especially with regards to senior employees with large command of government programs and official information and so on, the government had a big public financial disclosure program that would make sure that the personal interests of senior appointees would not conflate with their official responsibilities. And so had a lot of interesting opportunities to engage with regards to financial crime risk, conflicts of interest, risk and compliance. And through that lens, it gave me a unique kind of view into the U.S. enforcement arm and what it means and how it stands.
And did you feel that, you know, the enforcement threat from prosecuting authorities in the US was taken seriously by corporates?
Absolutely, I do believe. And the thing is, there's a track record there, right? It's public. It's on the DOJ website. The cases that are brought in every conference and seminar, there would be a tally of the enforcement record that the department was racking up, and so that would really set the tone for compliance failures won't really be tolerated. Now you have three buckets if I think about it, right? You have the compliance world, prevention, financial, the risk prevention world. Then you have the investigations, the pre-litigation world, and then you have the litigation disputes world. The question is, which world do you want to live in, right? Do you want to do you want to invest your time and put your money up front and just stay in that prevention world, the compliance world, or do you want to be faced with investigations and lots of questions as they dig to see where the investigations go? And I can talk more about some of the high profile investigations like the Mueller investigation, but do you want to be in that questioning investigations world, or do you want to be in the litigation disputes DPA monitor world?
Yeah, and I imagine most people, if not everyone, will say they want to live I want to be in the compliance world, and I don't want to be sitting there with an investigation and having to deal with all those issues. But in that overview of work, it seems that you've got to understand the kind of narrative that helps corporations and organizations get on board with helping them live in that compliance world. Is that fair to say? I know a lot of your background work is investigations, but do you find that work and experience in the prosecution authorities on investigations has enabled you to, I guess, find better language to persuade companies to live in the compliance of those three worlds?
Yes, absolutely. I think, I am personally and professionally invested in the special relationship between the US and the UK, right? So these topics of comparing.
Yeah, well said.
Yeah, I voted in both elections last year, right?
Okay.
So, when we compare enforcement regimes and agencies, it's no secret that the US was leading and could do that. The UK, on the hand, hasn't had as strong and a long enforcement record, so it's had to turn to other forms of persuasion, and we can talk about that later as well. But being in Washington, D.C., the DOJ bringing high-profile cases that made news around the world really had an impact on my understanding of the messaging, and that fueled being a part of the enforcement agency. Fuels a lot of the talking points for educating the corporate community on the compliance side.
Yeah, we can touch on that later on, maybe when we take the US and UK perspective, because I think one of the issues I know people working in compliance and prevention and counter fraud faces getting the buy-in from the top in terms of why it's so important. And there are some organizations that got great maturity and that's not a problem. For others, it's a difficult conversation to get the budget for what is essentially a cost center. Now, you just mentioned the Mueller investigation, and you were working there at the time, and this was all about the interference with the election, the US election in 2016. Can you just give like a little potted history of that and your time involved in that, because that was really fascinating, and I think it gives context to your skill set, I suppose.
Yeah. The Mueller investigation was off the back of the 2016 presidential election between Hillary Clinton and Donald Trump, and an office of special counsel was set up just for this purpose of investigating. And so when I described the 30 component offices, I, as a lawyer at the time, having had 7, almost 8 years of experience in the risk lawyer role, was assigned to work with the Office of Special Counsel, some of the super lawyers, as we call them, in order to review financial disclosures and make sure the integrity of the office and the integrity of the mission was kept. Now, the scope of that investigation was to look at any ties between the Russian government and the Trump campaign with respect to influencing the outcome of the election. And like any investigation, you don't know where it's going to go. You have 3 big teams investigating different things, and prosecutors and investigators have to get into the detail of understanding, what are the risks and where this can go, and what information needs to be available, needs to be confidential, needs public disclosure, needs to go to Congress, et cetera. So this was a high-profile investigation, and one in which really brought a lot of the lessons to bear beyond just the day-to-day of investigations and lawyering, but then also the wider consequences as far as media and the knowledge that the public wanted to have.
And you can draw that to any kind of investigation for any corporate client, can't you? In the sense that there are so many of the commercial factors that come into play in terms of where that investigation goes and ultimately what the outcome and decision making is, I suppose, at times as well. Now, we heard a good quote yesterday at an event we were both at about how in-house lawyers and compliance professionals are essentially now the front line of policing. And this whole concept of, like, I suppose the second part of this webinar about controls beyond cost. Now, we talk about compliance is about following the law and making sure that your organization is abiding by the law, and it's, for some it can be dry and some it can be a cost center, but you came to the UK to do this part of work, which was fascinating. Now you came here to work at HSBC, and it's probably worth just talking a little bit about what you came in to do, because I think some of the learnings from that experience are really useful to share as we go through.
Yeah, so before I joined HSBC, I did watch a Netflix documentary called Cartel Bank.
Right.
part of the
Okay.
Dirty Money series, and to understand what I was getting into here. So you have a big bank, um, had a DOJ, DPA, Deferred Prosecution Agreement, and monitorship because of activity out of its LATAM region, Mexico City, which was coined the bank of choice for the drug cartels, literally bags of money.
Right.
And
Okay.
so the controls from headquarters were not translating down into region, of course, and perhaps headquarters was turning a blind eye. The profits, the money was looking good in region. And so I understood that the bank was investing in a transformation remediation program off the back of that. I came with an independent relocation after both remote and in-person interviews. But at the time, during the few years that I was there, there were former FinCEN attorneys, OFAC attorneys, DOJ attorneys that were brought in to support this transformation and remediation. So it was a moment in time to parachute into the bank and help support its program there. Now, that is a big investment that I was joining when there was a $1 billion compliance program, 8,000 employees, the latest technology and proactive investigations, big data to find the criminal networks that you can imagine. So the bank was striving to be an industry-leading enterprise. But there are a lot of lessons to be learned from that for small institutions around proportionality and sustainability of their controls, even if they don't have that kind of investment. And then also the communication, the feedback loop that needs to happen in order to make sure that your front line, your first lines of defense, business leaders understand what's happening and the value of making that investment so that you stay in the compliance world, the prevention world, and not in the investigations or litigation world.
Yeah. And I guess, we could probably blur the lines here between both financial services and non-financial services, but $1 billion and 8,000 compliance employees is not something that's available to pretty much most other organizations. And certainly organizations which aren't in the financial services sector, they're not going to have a high headcount on these areas. So what are the relatable things you think, okay, big project, huge numbers with HSBC. What can you take out of that and say, well, actually, I can distill out of that and say, well, you know what, for everybody, these are some useful things to know and to think about when you're developing your compliance program or that continuous improvement of a compliance program.
Yeah, well, it starts at the very basics, right? Taking a look inside of what are we doing now? What are we doing? Because we're going to move to take proportional, sustainable steps beyond what we're currently doing. So that gets the basics of the risk assessment and within the context of a risk appetite and looking at what you have existing as far as policies and procedures, systems and controls, and then building from there. With clients that I've worked with, it is a good thing that they're looking at what are their competitors doing. How can we benchmark? You look at your competitors for everything else, right? Their market share, new innovation, advancement, what they're taking on, the risks that they're taking, everything they're doing. So when it comes to compliance, the same philosophy should apply. And being able to see that even in whether you're an FS regulated or a corporate that doesn't have that same type of scrutiny, that you understand where you are, your current state assessment, and where you need to go from there. And then, investing in the internal advisors, legal and compliance, giving them a seat at the table early, but then also externally as well to make sure that horizon scanning and the wider view that the externals will have can be implemented.
Yeah, I think that one of the challenges is, okay, maybe it's more prevalent in terms of benchmarking against what others are doing because you've got the new financial crime guide from the FCA. So for financial services, you've got to look across about, okay, we know what everybody's trying to get to, but in the non-financial services sectors, it could be manufacturing, it could be retail, it could be food, it can be construction, whatever. How easy is it in your experience to benchmark? Because some part of that benchmarking, it's like their competitive advantage. It's, we're doing things really well here around compliance, and that's an advantage for us for winning work. We don't want our competitors know how we're doing what we're doing. Have you got any thoughts around that challenge?
Well, I mean, these are the conversations that need to continue to have in the communities of practice. I mean, you need to be out there in the community of practice, engaging with your peers and pushing the discussion, right? I mean, you and I were at a City Forum event last night, and we see how important it is to be raising the pushing the conversations between City of London police, big banks, household name banks, academics, fraud professionals, to really understand, what's required and what will protect us. And so whatever sector you're in, whatever forums you're going to, whatever discussions are being having, that you're making sure that you're staying engaged and pushing the conversation, wanting to push the conversation. And that goes for both the compliance team, but then also your frontline business people. And quickly, just to reference, I mean, at HSBC, one of the roles that I had, I worked in the policy teams and I worked in investigations team, but the value proposition work was one of the most interesting roles that I have, where, I recall an email that was the subject line said, to discuss the £7 million investment or spend costs that the business was putting into the compliance technology, right? They wanted to know, where is this investment going? And they want to be educated. They wanted to make sure that the conversation, the discussion was being pushed and had.
Yeah, and I think that kind of having a peer group is really important. So I know in certain sectors, housing associations, I talk about quite a lot. For example, that there are still like there's little talk groups, or there's forums where they get involved and they share the stories, because they then, I suppose, help learn anecdotes, horizon stuff, but allows operational staff in their organizations to see it through their eyes about, what is it like sitting in a compliance role or a governance role in this organization? What is it I've got to do? How can you help me? And until they can see it through your eyes, it's really difficult. And that peer networking is really important. And one of the things, I guess, that comes up at these, the events we go to, also quite a lot, is whistleblowing. And as I say, that's how we first met. And Paula came up with the title from Washington to Westminster, and that's pretty much
well done.
Where we met at that Whistleblowers Awareness Week, and you were talking. Now, it's kind of the US perspective as again, if we can touch on that, because the US has done a lot more around whistleblowing than we have here in the UK, and there's much more positive conversations now coming around about the Office of the Whistleblower. And the bill that's going through Parliament about this independent office being set up to also receive whistleblowing complaints, apart from a regulator and the organisation at which a protected disclosure is given to. But and also maybe to talk about incentives and rewards. So what do you think made whistleblowing tick more in the US than perhaps you might have seen it ticking over here?
Yeah, I think there's two buckets to think about this. There's the cultural norms and that bucket, and then there's the legal regime and the legal norms in that. No, culturally, it won't be a surprise. I recall writing an article last year at a prior firm comparing the two countries and their approach to whistleblowing, and it was like the US sprints forward and the UK considers ways closing the gap, right? I mean, since I've been here 7 years, it makes sense. This sort of this approach by the enforcement agency to just push forward and sprint and try this 90-day pilot program that the DOJ announced at a big conference the other day, and say, we're going to do this and as fast as we can. And the UK evaluating and looking at that. So there's a cultural thing, but I think it makes sense on a human level, and the SFO director speaks often about this, and he's pushing this. A human level, incentivizing whistleblowers makes sense, right? They're risking a lot, their livelihoods, they're supporting their families, etc., and they need backing. They need an insurance policy. They need to understand that when they blow the whistle, that they will be protected. That's from from a human perspective, I think that goes across the pond. But then the legal regime is different. Whistleblowers in the U.S. can have a bit more confidence about the protection they receive, and that gets into privilege, and that gets into the legal system compared to what they may be compelled to produce here in the UK. So sometimes there's a disconnect because it's clear that the cultural and the human considerations, but then you have two different legal regimes. And as you said at the top, I'm a US qualified lawyer, and I appreciate the difference between the UK regime and the application of the law here.
Yeah, but I think it's interesting about you saying that the US will just get on, and they did their 90-day sprint, which I wrote down here. It was like the corporate whistleblowing awards pilot they did in September 2024. And, there's a kind of baby steps approach from maybe the UK that we'll dip our toe in, see if it's not too cold. We might go in a bit further. And kind of the impression I get is that the US goes at it a lot quicker. And they
for better or for worse.
For better, for worse. Yeah. I know you joked before we were doing this that you didn't want to be the US lawyer telling us how to do things, but
exactly.
It could work, it could not. But for me, whistleblowing, it's integral to everything around transparency, integrity of an organization. Ultimately, we want to get our people in an organization talking about wrongdoing. And do you think when people in governance, compliance, even investigations, when they're thinking about their whistleblowing setup in their organization, do they forget that the whistleblowers, the journey they've got to go on, that need for that insurance policy? Do you think that culturally we don't quite think about that human element? Maybe more like you might culturally think about it in the US?
Maybe. And I mean, through my lens, the stories do matter. And I don't, that you could say there's Hollywood, there's all this fascination with the individual narrative and then the media and the publicity around individual case, whatever it is. And we live in an age of social media as well. I can understand and connect to that, sympathy with the individual whistleblower and the protection that they will need and the support that they will need. There's that contrast with sometimes a tough reality of, the corporate entity, right? And legal and compliance. Every company may do it differently. They have their hotlines reporting goes into the legal and compliance teams. They have a form that says whether you're reporting anonymously or giving your identity. There may be this whole setup that differs from corporate to corporate. But there is a corporate entity there, and there are questions around, whose interests are being represented, the corporate, the individual, and the risks that the corporate faces to the individual whistleblower and insider threat. So I understand the complexity and the nuance sometimes that can perhaps sometimes overshadow the human story, right? That we.
And I just think I think the better programs I've seen is where there's kind of respect for the human story, albeit sometimes we do get, acknowledge it. We get whistleblowing sometimes where it's people with wild conspiracy theories, or they are trying to engineer an issue, but there are then genuine reports in there. We've got to kind of factor that human point in. Now, you mentioned earlier, just when we were talking about whistleblowing, about privilege, and could you just talk us through why issues on privilege in the US, in your perspective, might be more advantageous than privilege here in the UK on whistleblowing?
Yeah, so there's more whistleblowers and individuals can expect more things to be covered with privilege in the US. Anything from the distinction between legal advice to compliance and business advice to impressions that are recorded, et cetera, to the ability of lawyers to protect testimony. That is, there is a difference between what can be compelled in UK courts and the protection around privilege. Now, on a human level, we can see how sensitive this is, right? Everyone has WhatsApp chats and with different family members, right? The whole psychology of it is confidence, right? You want to know when you give information, when you share something, you want to know who it's going to, and be assured that it's not going to someone else, right? And so if we break down the concept of privilege just to a very everyday use, that we're careful, who are we sending this to and who's receiving it, whether it's WhatsApp, email, etc. And so with a whistleblower who's sharing information and disclosing, this concept of what will be privileged and what will be protected is quite important. And I think some of the best tell-all books are when insiders don't reveal information until after the fact, and then they're finally ready to share and have this disclosed. But there's a timing thing around what information is shared and when.
Yeah, and I don't think, well, obviously in the heat of the moment, nobody thinks about these things, and it's always lawyers and coming back with 2020 vision in hindsight, saying, okay, what we attach privilege to or what we don't, it depends in in one context for a client if it's engagement with a regulator or not. Now, continuing with this kind of tension between organizations and whistleblowers, the tension maybe within an organization is around the desire to improve a whistleblowing program versus the difficulty to embed that change and maybe have that change trusted. Now, part of this approach by Whistleblowers UK and other organizations to champion this Office of the Whistleblower new government department is one way to alleviate concerns of whistleblowers. There's this independent body that people can go to who will investigate matters instead of your employer or a regulator, and you're meant to get some assurance out of that. What's your take about that? Because I don't think there's an Office of the Whistleblower in the US, but there is one in Ukraine. What's your take? If you're an organization and you're horizon scanning and you're telling them, look, this is coming down the track. Should organizations be worried? Well, I mean, just generally, what are your thoughts?
Well, Georgina will be happy for me to endorse the Office of the Whistleblower, and I think it is an issue when we look at the comparative landscape that makes sense. Now, there are complexities like every other new office, new government agency, and with how does it reconcile with the existing reporting mechanisms, and how should corporates think about it all, and et cetera. But I think that the big picture and the key thing is, as we said at the top, in rules without enforcement don't mean much. Yeah. And you need to understand how can you enforce the rules and how can you drive home the mission. And sometimes analogies come to mind, and you can always advise me if it's off kilter. But I receive a speeding ticket for going 5 miles over, and I'm scoffing at it.
You didn't declare this to me earlier. It's all over.
I may or may have
not. You may, yeah. Okay. Well, we're recording it now. You can't take it back.
And I'm scoffing at it, saying, oh, just 5 miles. I mean, that's this enforcement that's happening here. But then I go to a driver awareness course and am educated on the difference that makes, and I understand what could happen, the risks and everything. The key is that it wasn't just a speed limit there. It was enforced. I had to receive education and awareness training. I digested that. I understood it. Now I'm a believer. And now my daughter in the backseat and everyone is calling out the speed limit, saying it only says 20 miles an hour. So, again, what are rules without enforcement, and how can government agencies best enforce the rules, and how can we create that awareness between corporates and those responsible stakeholders to engage?
Yeah, and that's like an age-old challenge, isn't it? How do we get stakeholders to engage, or how do we get the executive management to engage? Have you found that conversation different here in the UK compared to the US? Is there something you've learned from engaging corporates in conversations to adopt improved compliance programs? Is there language here in the UK which is taken from your experience in the US?
Yeah, I do think so. That is how I was trained and brought up in the law to start my career for 8 years in the U.S. system and in the federal government. So I take a lot of that experience to bear with the 7 years of private practice that I've had here in London. And I think, the conversation from a U.S. perspective, really does come down to understanding how enforcement works. And when I can articulate that, then I think that helps spread the awareness. I wanted to mention that there was a book written on the Mueller investigation by a lead prosecutor named Andrew Wiseman, and I wrote it here today, called Where Law Ends, Inside the Mueller Investigation. And he described in this book, the difference between the FBI as a component agency and the U.S. DOJ. And he was saying, a common FBI agent complaint is that prosecutors are too timid, refusing to bring difficult cases that they may lose. And a good prosecutor needs to temper an agent's enthusiasm for bringing a case with a cold, hard assessment of the facts and the law, the question of whether a case should be brought, even if it can be brought. And understanding from an enforcement standpoint how a prosecutor thinks, how an FBI agent thinks, how do these enforcement personnel go about thinking about the law, that can help inform the business commercial leaders around how they need to be thinking about it. Again, if we're in those legal and compliance folks who are in the church or the synagogue or the mosque, as we say, right? They are there getting the messages in the community, in the church, from the pulpit, etc. And usually their job is to now go out into the world and spread the gospel to the business leaders, to the folks out there, right? So how do we bring those people into the church, or how do we bring those others out into the understanding that the compliance legal teams have had? Or how do we translate? How do we take clips and bits of understanding and translate that into the business, into the front line, so that they can understand too, and they become believers of this compliance view, and they can do that. And so I think that that experience and reading the book after I left the department was key. One more quick recommend for those interested in the U.S. experience: Doing Justice by Preet Bharara, who is the U.S. attorney for the Southern District of New York, who he has a podcast out now called Stay Tuned with Preet. So I still follow my U.S. attorney leaders there, and he references in his book the importance of questions. Whether that you should be asking so many questions. They could be broad questions, narrow questions, uncomfortable questions, long shot questions, repetitive questions. Some questions should be asked twice, maybe even a third time. This is in the world of investigations, right? And understanding that this is how enforcement thinks. When you're in that world, when you stepped out of compliance and now you're in the world of investigations, okay, this is how the enforcement agencies, at least in the U.S., think. And we know the SFO director, because we hear it at every conference and event, he is taking a very proactive approach. He is being very public around the importance of whistleblowing programs. He's looking across the Atlantic. He's talking about looking for a fraud case, FTP fraud case. He's talking about being on the front foot. He says, "I'm a man you can do business with." I mean, he is very much sounding familiar in some ways.
Yeah, I see where you're going with that. But it's you need those sound bites coming out, because I past experience, I've seen all kinds of different people on boards. Some saying, look, we don't want another center-led initiative where we're telling everyone to get on board with more increased compliance, and we don't want that to happen unless there's a real risk to us on the board, and that's quite a narrow, disappointing view. And then you get those who are, we've just got to be all over it. And it's interesting, isn't it? Because things things are really moving in the space. So we see there's a lot more data-led kind of approach now to compliance, and I have seen, and you've seen, different in separate organizations, we've seen different tools using AI now to undertake investigations, upload a lot of information to Gen AI and large machine learning capability, and it's saying, look, you tell us what you're looking for, what you think your case theory is here, and we'll look for all this document, and it comes out with a little report for you, and it gives you a steer of where to look in a bit more detail, or what might be happening. What's your, are you pro use of data in investigations? Do you think organizations, in-house organizations, should they be using data, or is it, there's nothing better than the human skill set? Or is it a combination?
A combination. You got it. Well, so you said to treat this like a coffee, Aaron. So apologies if the analogies are getting too much.
No, keep going.
I'm a big fan of data, right? Whether it's 10,000 steps or how much sleep you're getting, data empowers you with the knowledge that you have. And I have, in my experience, worked with multidisciplinary teams where there are big data analytics programs, and that supported and underpinned legal and compliance advice. The more information that you have and the technology that you have can not only educate, raise awareness, but then also give the kind of advice that helps make commercially sound decisions. You rely on data, again, for competitive advantage, to grow and expand, to move products into market, et cetera. The same thing should be with your compliance program, not thinking of it as a cost center, but thinking of it as an advantage to be on the front foot of that information. And we know that the fraudsters are collecting data. We know the value of data of individual customers. That's how the big tech works, to make sure that you get the right algorithms and the right advertisements and everything is going there. So you're, as a consumer, the world of data is impacting you every day. So you need to, how can you as an individual and you as a business use data as well to make sure that you're protecting yourself and that you're protecting your customers and that you are moving forward with your mission.
Yeah, and I think that's something for everyone to I'm sure everyone keeps in mind now, is that use of data, and it's going to be relevant in relation to the FTP. And friends, let's talk about failure to prevent, because I know that's on topic for everyone. You've talked about it's the standard approach, isn't it? There's lots of kind of sound bites around failure to prevent fraud. I mean, I think people know that they start with their risk assessment and looking at the policies and their risk appetite and so on. I know when I'm talking about it, I say look at past events and say, would you have committed an offence under Schedule 12 of the piece of legislation, one of the offences in there? Understanding the reach is probably something which organisations are starting to get a feel for if they've got any international ownership or issues of that nature. Now, just as an overview, what's your take of listening and starting to understand about the failure to prevent fraud offence? Do you think this is, when the Bribery Act came out, we said, hey, this in the UK, we said this is the gold standard and it trumps the FCPA. So what do you think about the failure to prevent fraud offence? Do you think this is the gold standard?
Well, time will tell, but this is an important statement and an important piece of legislation that's come out. It starts with large organizations. So as we know, we're talking about 250 employees, not 250 followers, online or whatever, employees. So in a millions of dollars of turnover and assets.
Volume of assets, yeah.
Yeah. So we understand this, like the group that it's going big business, and when the SFO director said he's actively looking for a case and it comes into effect 1st September, that puts companies on the alert, and so the investment to be in that compliance world naturally needs to happen, and all eyes will be on to see, okay, who's going to be made an example of, what case activity, what's going to happen. And it has the kind of reach that goes beyond the UK. And so it is one in which I think multinationals and US firms should also be paying attention to.
Yeah, and I think that reach is something which I don't think people or organizations outside of the UK naturally understood early on. And it's, probably most people on the call know it. It's, as long as the offence takes place in the UK or it affects a UK citizen, you're going to be caught by this offence. So you don't need to have a trading, operating business here, and you don't need to be domiciled here. You don't need to be incorporated here. You just need to touch point here and its impact. But of course, it's outward facing issues. If you're thinking about organizations that are overseas and you're advising on that, what's the first things they're going to be looking at in terms of the FTP offence? What do you think they need to have high on their agenda? Do they need to be thinking about what are the offences, or do they need to be mapping out the geography of the organization? What's the best approach?
Yeah, well, they're certainly going to have to be thinking about their touch points, as you said. Can a relevant event take place in the UK? Can fraud, be impacting victims, customers, owners or creditors of relevant organizations? That's some of the main touch points. But beyond that, sort of, will it catch me, kind of thing. This is the time to be looking at your current state assessment, your existing policies, procedures, controls, and where are the incremental, proportionate steps that we can take where can we kick the tires to bring it up a notch, and to be in agreement as far as reasonable procedures, so that the regulators in the UK can be comfortable with this, because as I said, the special relationship between the US UK is close to me. I pay attention to it from an enforcement standpoint, but even amidst times when it may not be as clear exactly where the priorities are, if companies think about the big picture, the long term, the 5-year, the look back periods, the statute of limitations, that conduct can be reviewed that took place years ago, you might as well get your house in order. You might as well get started now. Use this, especially legal and compliance, use this as a impetus to say, let's make the investment, let's take a look, because it may not come knocking tomorrow, it may not come knocking next month, but it could be a year down the road, just as you're launching a nice new product and you don't want the reputational, the inquiries, all of the things. Again, you want to stay in this compliance world. You don't want to be, you want to be industry leading. Why not protect yourself for the short and the long term?
Yeah, and I think this legislation is all aimed to making sure that organizations aren't committing fraud and causing fraud. But there's got to be a really positive byproduct here, that it's going to help them stop being victims of fraud as well. And, the offense isn't if one of your employees causes fraud against your organization, you're not caught. But surely this kind of regime is going to help organizations find that invisible extra money on the bottom line, because that's the conversation every time about why do we invest in compliance? What's the return on the investment apart from we're complying? And you don't know how much you save because you don't know what you don't know. But there must be a saving for businesses here by implementing this as well. It's not just a cost.
Yeah, no, absolutely. I mean, you're letting your employees know that you're looking at this. Now, employees will know, whether trial and error or because of some training, that the company will protect its information. So if you have access to information of the corporate information, and you try to email it to yourself, to address it, then there will be usually a warning. There'll be some sort of control. So there'll be surveillance on official work email. There'll be some sort of control that will make sure to protect the corporate from activity. If you also understand that the corporate's investing in the sort of controls to make sure that you, as an associate and of that corporate, are not acting fraudulently on their behalf because of this failure to prevent fraud, where they could be caught up in an associated person acting on their behalf like that, then that also sends the alert that, the responsibility that you have to make sure that not only is the company not a corporate victim, but also not engaging in that kind of conduct externally.
Yeah, there's the deterrent effect. I think, from my side, and I've been seeing this go through for a while now. Now the offence is almost here in terms of going live. It's a really good thing. It's a good thing. But I do think the way to keep that investment going is it's saving us invisible money, because it will be a deterrent. It will, to suppliers as well as internal threats. So that's a good thing. Well, that's wrapped by really quickly. Tristan, thank you. I did warn you. I'm gonna take your phrase and spread the gospel. I'm gonna tell everyone, go spread the gospel about compliance in our learnings. I think it's really important. It's really tough for anyone who's dealing with the front end in the investigations. It's a lonely world, and I think there's a community out there people can learn and share that. That's great. So look, thank you for hanging out again and spending some time and talking to those who can attend. As I mentioned, there's a feedback form that'll be popped into the chat. If you could fill that in, if you get a moment, that'd be really great. Just helps us about thinking about things, including other topics of interest and so on. You're welcome to obviously reach out to Tristan and I about anything we've talked about today. Now, if I could just ask you to save the date as well. 1st of July, we are having our next At the Coalface. It's going to be with Perrin Carey, who is at a company called Coasteer. They're a technology company that measures organizational governance and culture. And we're going to talking about human data. And we're going to discuss how aspects of culture influence decision making around choices, decision implementation around actions within the workplace and life, influence fraud taking place in your organization. So how do you draw a line between culture and fraud taking place, either to your organization or getting through your control? So that's going to be on the 1st of July at midday. So hopefully you can join us for that. I'd say on the questions, I don't think we've got any this time, which is always sometimes a blessing, because you never quite know you can answer them. But so I'm going to ask just one question, if I can, Tristan. If you had your way, what would you, in today's world, take from the US to implement in the UK, which we haven't got already, to improve the battle against financial crime and fraud? I know, just top of my head.
I told you I didn't want to be that guy that just
tells you. But no, not let's say, okay, from what you've seen around the world, let's not just say the US does it this way, so it's right. I get that, but is it the numbers, the support for the enforcement agencies? What do you feel has worked there, which you know it could work here?
Yeah, I think we live in an interconnected world, right? And in some ways, online, a world without borders, and technology is certainly moving at that standpoint. And I just think, the legal regime and the conversations that we have from a legal standpoint need to think in that interconnected way more and more. We already have secundies coming across, sharing information. You have alliances, anti-corruption alliances between France and the Swiss and the UK. You have this kind of cooperation. But how can we push that even further? Like, how do we, and I don't have the answers per se, I love, any sort of activity around trying to bring the international regulators together and pushing the conversations more and more. But we just have to respond. The fraudsters, the criminals are borderless. And so on the enforcement side, on the legal and compliance side, in response to that threat and technology, we need to find out how to incorporate those lessons and those learnings more. And yes, there may be the human side, and there may be the legal reality of our systems, but how can we, bridge the gap a bit more? So, conversations to keep having.
Yeah, absolutely. Well, look, thank you so much for making time. I really appreciate it. Thank you, everybody who's attended today. I really appreciate it. And if you're watching this back, thanks for taking the time to do that. I know this, again, there's a lot of content, so appreciate it. And hopefully for those who are still here, see you on the 1st of July. And yeah, I wish you a good rest of your day. I'll give you 4 minutes back of your day. Thank you very much.